Ready, start. It would therefore be appropriate that an educational tribunal be set up in each district in a state, the object being that the teacher should not suffer through the substantial costs that arise because of the location of the tribunal. If the tribunals are limited in number, they can hold circuit oblique camp sittings in different districts to achieve this objective. Till a specialized tribunal is set up, the right of filing the appeal would lie before the district judge or additional district judge as notified by the government. It will not be necessary for the institution to get prior permission or ex post facto approval of a governmental authority while taking disciplinary action against a teacher or any other employee. The state government shall determine in consultation with the High Court the judicial forum in which an aggrieved teacher can file an appeal against the decision of the management concerning disciplinary action or termination of service. The challenge made in the writ petitions to various provisions of the said Act and the said rules are in respect of such provisions which require prior approval for any disciplinary action, including in respect of even suspension. A further challenge is to the provisions requiring the presence of a nominee of the Director of Education on the disciplinary authority. The challenge is thus based on the judgment in TMA Pi Foundation's case Supra, which had held that there was no reason for the management of a private unaided educational institution to seek consent or approval of any governmental authority before taking any disciplinary action, and it is in the ordinary relationship of master and servant to be governed by 1.62 terms of contract of the employment, which would hold the field. The observations are to the effect that there is no necessity for either prior permission or ex post facto approval of governmental authority while taking the disciplinary action against the teacher or any other employee. The rights of such a teacher have, however, been protected by providing for a tribunal to hear the aggrieved teacher so that the teacher is not compelled to go through the route of normal civil litigation in respect of a master servant relationship, and the district judge has to act as the tribunal pending necessary enactments in this behalf. It is in view of the observations of the Supreme Court that the claim made in the petitions are that any such provisions requiring prior permission or concurrence or ex post facto approval would not withstand the scrutiny of a constitutional challenge and would be violative of the provisions of Article 19 1G of the Constitution of India, hereinafter to be referred to as the Constitution. It may, however, be noticed that the said Act already provides for the constitution of a tribunal under Section 11 of the said Act. Such an appellate tribunal is, however, restricted in exercise of powers only in respect of matters dealing with dismissal, removal, or reduction in rank in view of the provisions of subsection 3 of section 8 of the Act. The government of National Capital Territory of Delhi and the charged employees have both defended such provisions as being salutary in nature to protect the interests of teachers. It has thus been contended that these provisions having a statutory flavor cannot be struck down. Before embarking on a discussion on various provisions, it would be useful to refer to judgment of the Supreme Court in Brahmo Samaj Education Society and others versus State of West Bengal and others 2004 6 SCC 224 delivered by a bench of two judges. The effect of the pronouncement in TMA Pi Foundation's case Supra was discussed. Stop.